Hey everyone, it's Rob Ryder. On Sunday, January 18th, 2015. I did a video yesterday. It was called Gatekeeper or Counter Troll. And in there, it was talking about an office called the Office of Solicitor General. And a lot of it focusing on the guy that's at the for the United States. But every state has one, or they have somebody doing that function, and they would be under the Attorney General. Some places they even have them at county level. I think DeKalb County is in Georgia, and so in DeKalb County, the Solicitor General is the one that prosecutes misdemeanors and low-level crimes and ordinance violations and things like that. But it's also the person that you go to instead of going directly to the court to get a prerogative writ. And this is starting to make more sense to me now after all this reading and years of thinking about this. Oh, another light bulb comes on. The prerogative writs come out of the King's Bench, and the King's Bench is a court of law. And in the court of law, you have to have your paperwork squeaky clean perfect, or they don't have to look at it. We don't know how to do it. You need to be learned in the law. And the guy that's learned in the law by statute to hold the office is the Solicitor General. And so he'll do the paperwork squeaky clean and put it into the court to get the writ. Right? We go to him to get the writ. You don't go directly to the church. Yeah, basically to the court, to the King's Bench, to the Supreme Court, to the court that has jurisdiction over prerogative writs. Right? Writ of Certiorari, which we're going to be spending a lot of time on. Mandamus, prohibition, quo warranto, which we're going to want to use. These all come out of the King's Bench. So whoever can issue those is the King's Bench. And you don't want to appeal directly to the King's Bench because it's a court of law and you don't know what the paperwork's supposed to look like. So you want to petition the guy that does the business for the country with the Supreme Court, which is the Solicitor General. He's the one that represents the state of Michigan or the United States or whatever it is before the Supreme Court. Right? It's not the Attorney General. Anyways, so these are what would have been called royal prerogatives back in the day when it was the king that had this. He was the fountain of justice, and through equitable jurisprudence, this idea of the king being the fountain of justice, so no matter what the courts did, the king could undo it because he was the king. And that became the Court of Chancery, and. So we're going to spend a lot of time on, well, I'm going to spend a lot of time, I don't know if you are, certiorari, writ of certiorari, because it's the one that we need to use if you're in a court case now or something else. But before we go there, I want to read a little bit about just the idea of the difference between equity and common law, because I think a lot of people are mistaken in their beliefs. And so it isn't what I think, it's what they think. They wrote it, right? The court. I'm going to read what the court said, and I'm going to go with what they say and see if there's something I can do with it. And then lastly, it'll be this PDF I found just on writs of certiorari, certiorari, writs of certiorari. That if you wanted to go to get it, right, you would just Google the writ of certiorari and maybe put in Frank J. Goodnow, and you're going to end up probably at this page here at JSTOR. And it's about a, 45-page definition, for lack of a better term, of a writ of certiorari. But, that's just one little aspect. That's one of the prerogative writs, right? There's many prerogative writs. So understand the prerogative writs, yes, what they are, and understanding we don't want to go directly to the court for it. We want to go to the lowercase Attorney General if you were reading Blackstone or something like that. So here we go. But first of all, let's just do Here's one of the things it said on that this PDF I'll be reading at some later time. It may actually be in another video, but it says on page 10, but in general, our only method of appeal from administrative decisions has been by certiorari, and we have therefore been obliged to give to this writ a development which has greatly enlarged its scope and usefulness. Now, this is a guy speaking specifically about the United States, right? But it applies any place that has the prerogative writs. They're just maybe called something different. They may not call it the writ of certiorari in England anymore. They call it judicial review. And I listened to a video from a guy from England, an attorney, old attorney professor, explaining that the royal prerogative, which the certiorari is, there's 4 reasons you can ask for it. One is irrationality. 2 is illegality. The 3rd one's procedural impropriety. And the 4th is human rights violations. Excellent. You want to ask for a writ of certiorari. Because they're certainly not following procedures, and what they're doing is illegal. Or irrational, right? Either they're out of their mind or they're just criminals. Personally, I think that they're demon possessed and they need to have an exorcism, and once that happens, they'll say, oh my God, what have I been doing? And they'll be asking for forgiveness. But until then, we need to ask for the writs. So certiorari, often abbreviated cert in the United States, is a writ seeking judicial review. So some places may be called judicial review, and some places when you see judicial review, you say, well, that really isn't what we're talking about, because they gave judicial review apparently more than one definition. But writ of certiorari. It is issued by a superior court directing an inferior court, tribunal, or other public authority to send the record of the proceeding for review. So it don't just have to come from the court. If it's any kind of administrative matter, your only remedy is certiorari. So, you have to start thinking about all the other things that it could be used for, but DMV problems, or I'm thinking more about things like trying to get your title deed to your property. Yada, 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 right? Because somebody's keeping your property from you. So we want somebody to review the record. And so etymology, present passive, thus certiorari translates to be informed, appraised, or shown. We're going to show them where the errors are. Historical usage, back to the Roman law and modern law, certiorari are recognized in many jurisdictions, including the United States, Britain, Canada, Philippines. Ancient Rome. In Roman law, certiorari was suggested in terms of reviewing a case, much as the term is applied today, although the term was also used in writing to indicate the need or duty to inform other parties of the court's ruling. It was a highly technical term, appearing only in jurisprudential Latin, most frequently in works of Ulpian. And, they talk about Roman law. They're either talking about Roman law before the Christians took over or Roman law after the Christians took over. Because the Court of Chancery, came out of Rome. The term certiorari, often found in Roman literature on law, but applied in a philosophical rather than tangible manner when concerning the actions of review, babble. Common law and commonwealth. This is more for, anybody who's had the Union Jack over them at any point in their history. They left you this, common law. At common law, certiorari was a supervisory writ, serving to keep all inferior jurisdictions within the bounds of their authority, protecting the liberty of the subject by speedy and summary interposition. Does anybody argue that that would be something that you may want to use? I don't think so. In England and Wales, and separately in Northern Ireland, and if it was in England and Wales, then it's wherever the laws of England and Wales were used, and that's Blackstone, and guess what? That's America. The Court of King's Bench was tasked with the duty of supervising all lower courts. So who has superintending control over the courts in your state? Your Supreme Court does. Then it's the King's Bench. and had power to issue all writs necessary to discharge that duty. And if you go look at your Superior Court, Supreme Court, whatever it is, they're going to be able to do it. Whoever can issue the prerogative writs is, the court we're talking about. The justice of that court appeared to have no discretion as to whether it was heard as long as an application for bill of certiorari met established criteria as it arose from their duty of supervision. They don't have a choice. The problem is we're not putting the paperwork. Our application is incorrect. Because in common law, the least little mistake invalidates your paper. You've got to have a man learned at the law draft up the paperwork. So back in the day, right, you would go to the Court of Chancery to get your writ that you would then take to the King's Bench. Right? So you didn't go to the King's Bench to get the writ. You went to the Court of Chancery to get the writ. And we're just been trying to figure out who the hell that is. And, well, it sounds like you go to this guy called the solicitor. And the reason I say that, just real quick, because we're going to be looking at this book of Chancery here, is because it's a book written for solicitors and masters. That's a word that's used in equity, and Chancery is solicitor. We'll get there in a minute. Okay, the justice of that court appeared to have no discretion as to whether it was heard as long as an application for a bill of certiorari met established criteria as it arose from their duty of supervision. They're supposed to supervise the courts, and that's what we're asking them to do. And if the paper's done right, they don't have a choice. So don't try to do it. Get somebody else to do it for you. The underlying policy is that all inferior courts and their authorities have only limited jurisdiction or powers and must be kept within their legal bounds. This is the concern of the Crown for the sake of orderly administration of justice, but it is a private complaint which sets the Crown in motion. They ain't going to do it unless you bitch about it. Complain. Ask them nicely that, hey, would you review this? I think there may be some errors. As Associate Justice James Wilson, the person primarily responsible for drafting Article 3 of the United States Constitution, explains, in every judicial department, well arranged and well organized, there should be a regular, progressive gradation of jurisdiction, and one supreme tribunal should superintend and govern all the others. I couldn't agree more. An arrangement of this manner is proper for two reasons. The Supreme Tribunal produces and preserves a uniformity of decision through the whole judicial system. It confines and supports every inferior court within the limits of its own jurisdiction. Right? So it'll support the court's right, and it will tell the court, well, you made a mistake. If no superintending tribunal of this nature were established, different courts might adopt different and even contradictory rules of decisions. Well, figure that out. And the distractions springing from these different and contradictory rules would be without remedy and without end. Opposite determinations of the same question in different courts would be equally final and irreversible. And, that's kind of what we deal with. So, what they just described to you is what would be a hierarchical system of government. One on top of the other. Boom, boom, boom. It's a hierarchy. It's just like the frickin' Catholic Church. Modeled on the Catholic Church, just is not supposed to be religious. Right? It's not. It doesn't have a conscience. It's just a system. You decide what side of the system you're going to be judged by. The unconscious or the conscious. Consistent with Justice Wilson's explanation, the power to issue writs of certiorari is invested in the highest court of every Commonwealth jurisdiction in some way, shape, or manner. While some incorporate this remedy into their constitutions, others treat it as implied powers. Decisions of an inferior court or tribunal or public authority before the superior court for review. So again, it isn't just the court, it's any public authority. You don't agree with the county clerk? So now let's think about this, right? Because we know in some counties they have people that they actually call the Solicitor General, and they do this shit for a reason. So okay, who has those functions where you live? Whatever he's called doesn't matter. That's should be your local Solicitor General. And so now if you've ever gone and dealt with counter trolls before and you get them stumped, they say, well, we need to go talk to our attorney, right? And so they go talk to the prosecutor or somebody like that, who writes up whatever he writes up and sends back. Deputy State's Attorney, whatever it is. But we could do the same thing if we just knew who to take it to. So we have a different attorney than they do. They're taking it to an attorney going in this door. We're going to take it to the attorney that goes in the other door. That's what it looks like to me. And, well, I don't know if it is. It just, if I had to try to form it into something, that's what I'm going to form it into until it's proved different. Federal courts. The United States certiorari is most often seen as a writ that the Supreme Court of the United States issues to lower courts to review the lower court's judgment for legal error, reversible error, and review where no appeal is available as a matter of right. That's interesting. See, when we go to court, they never give a final verdict or final judgment. Maybe in a capital case they do. Other than capital cases, death penalty cases and so forth, you go before a judge and he gives a summary judgment. Well, that's only halfway through the frickin' civil procedure. Yeah, the last one is called the final judgment, a declaratory judgment. And they never do that. Well, until they give a declaratory judgment, you don't have any right to appeal the decision because they really haven't made one yet. So that's the way they play their game. They just do it as a summary judgment and then get your consent somehow, or they already have your consent because of some piece of paper you've already signed back in the day, and they just take, they take superintending control over you. So we may not have an appeal as a matter of right. So appealing to the appeals court may not work because the case hasn't really been adjudicated to the final thing. So we want them to review the lower court's judgment, right? So now we're talking about review the lower court's summary judgment to see for a legal error. So, you're appealing their willfully false judgment by taking it to the whoever acts as the Solicitor General. And I don't think we all need to run to the guy at the United States. I think we're going to find out there's actually somebody that can do this function at whatever court you're involved in. Before some act, before Everett's Act, the cases that could reach the Supreme Court were heard as a matter of right, meaning the court was required to issue a decision in each of those cases. That is, the court had to review all properly presented appeals on merits, hear oral argument, issue decisions. As the United States expanded in the 19th century, federal jurisdiction system became increasingly strained, and okay, I don't know, we need to read all this, but right, so this is how it works right now, right? If you wanted to get a writ of certiorari now, a petition is printed in a booklet format and 40 copies are filed with the court. If the court grants the petition, the case is scheduled for the filing of briefs and for oral argument. A minimum of 4 to 9 justices, four of the 9 justices, is required to grant a writ of certiorari, referred to as the Rule of 4. That's if you go to the court, right? But if you go to the Solicitor General, he's going to probably just go to the Chief Justice and have the Chief Justice do it. So anyways, this petition, right, instead of you doing this, whatever this step would be, he's going to do it. The court denies a vast majority of petitions and thus leaves the decision of the lower court to stand without review. And in the video I did yesterday, it said that, right, that they only do, like 80 to 150 cases each year. But they take almost all of them that are brought to them by the Solicitor General. So we don't want to put paperwork into the court clerk. We want to put paperwork into the Solicitor General. Okay, conversely, Supreme Court denial of a petition for writ of certiorari is sometimes misunderstood to mean the Supreme Court approved the decision of the lower court, yada, yada, yada. Okay. In legal citation, cert granted sub norm is an abbreviation of a legal phrase. Certiorari granted sub nomine, meaning judicial review granted under name, indicating that the petition for certiorari of a case has been granted, but the court granting the certiorari is hearing the case under a different name than the name under which the subordinate court heard the case. Yeah, exactly. For example, the case of District of Columbia Heller was known as Parker versus District of Columbia in the court below. And this is because, when you're in court below, in the local court, that isn't your name up there as the defendant. It may be your property, but it isn't your proper persona. And so if they were going to do this, they would change it into your proper persona to hear it is the way I understand it. In some United States court systems, they use the same terminology, but in others, it's called a writ of review, leave to appeal, certification for appeal is used in place of writ of certiorari as the name for discretionary review of the lower court's judgment. Okay, so they may not call it a writ of certiorari. They may call it these other things, but what it is, it's a discretionary review of the lower court's judgment. So if you're trying to understand what it is, it's the discretionary review of the lower court's judgment. And I see this was hyperlinked, so what I'm reading came off of Wikipedia. And if you go find this and you go to this part where it's hyperlinked, right, it'll take you and it will explain to you what discretionary review is. For those that don't know, we got people from all different walks of life that walk into this stuff. For some of you, it's the very first video of mine you ever heard of, right? So go there if you want to know what discretionary review means. A handful of states lack intermediate appellate courts. Okay, well, none of that really matters. Administrative law. In the administrative law context, the common law writ of certiorari was historically used by lower courts in the United States for judicial review of decisions made by administrative agency after an adversarial hearing. Used by the lower courts in the United States for judicial review of decisions made by an administrative agency after an adversarial hearing. And they never let us get into an adversarial hearing. Everything we do is always in rem. They give in rem judgments. So in rem, it's a property hearing, and you never really showed up. That's why you need to get it to be proper persona, and then say, he's a liar, this is what the law says, and he's not doing what the law says. Oh, now we got a controversy. Okay, some states have retained the use of the writ of certiorari in state courts, while others have replaced it with statutory procedures. In the federal courts, the use of the certiorari has been abolished and replaced by civil action under the Administrative Procedures Act, yada, yada. Okay, it says all that, but it's already said that the Supreme Court, or the Superior Court, can still do it. These are all the lower courts that may have changed the way they do it. So, there you go. Okay, so if you could, please donate. The PayPal account is Ashley, ASHLEYRYTLEWSKI @gmail.com. Or you could mail to Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. Okay, and we're going to be going now to, I want to read some out of this book, but I need to go take care of something real quick, so I'll be right back. Okay, I think we're back. So again, just so I can get myself back to where I was, the royal prerogative is what the king had, and it's been transferred down to the king's bench. And it's the King's Bench that, well, let's say it's the King's Bench that gives out the writs that are issued because of the royal prerogative. One of those is the Writ of Certiorari, and that it allows you to have reviewed court cases and administrative actions. And done by a guy called the Solicitor General. And because of that, because you can find the word solicitor, chancery, equity, and as you see, I'm sure we get in here, prerogative writs, right? Pleadings, writs, orders. It's a good place to start because a lot of people don't understand the difference between common law and courts of equity. Well, we're going to see what a chancellor had to say about it because he's the guy that wrote the book. And as you can see, this book was right here. Is this one? Entered according to an act of Congress in the year 1907 by Henry R. Gibson in the office of the Librarian of the Congress. You know what that made this? It made this a frickin' act of Congress. This book is an act of Congress. It has to be defended by the Solicitor General. Ain't that wonderful? Oh man, we're gonna have fun with this. Okay, let's just read a bit. Wow, man. Things take so long sometimes. Okay, we're just going to read the very first article of Chapter 1, the history of the Chancery Court. Let's see where this came from. Okay, so here we go. The civil law, its development. The system of jurisprudence called equity was originally largely derived from the civil law of the Romans, and its early development in England was similar to the development of an analogous system in the jurisdiction or in the jurisprudence of Rome. Therefore, in endeavoring to trace the origin of the Chancery Court, it may well notice briefly the development of the civil law, which came out of Rome, Catholic Church, and of course, I don't say the Catholic Church, the Christian Church, because we're talking about things that started as early as 150 A.D. England had its first saint, and in 500 and something A.D. is when the Roman Church showed up, and the king decided, yeah, I like the Roman system, and that's the one he went with. There was some other one that was probably the Greek Orthodox, trying to think of what the difference would be, but the difference was they believed all the same things. They had different dates for events. So 550 A.D. or so, the church shows up, and the first abbey in Canterbury goes up, and from there is where the Chancery Courts come out of, to this day. So the system of jurisprudence called equity was originally largely, okay, we did know that, briefly, the development of the civil law. The early laws of Rome, like old common law of England, were exceedingly stern, rigid, formal, arbitrary, paying little attention to the abstract right and justice. The common law of England. Now we're talking about common law. Paying little attention to abstract right and justice. Formal, arbitrary. That's the problem with common law. Their judicial proceedings were technical to the last degree. Absolute accuracy was required in complying with the established phrases and acts. Let me make this a little bit bigger if I can. In the enforcement of civil rights. It can let me be that big. Bear with me. The computer a little bit squiggly today, acting kind of crazy. Okay, here we go. The early laws of Rome, like the old common law of England, were exceedingly stern, rigid, formal, and arbitrary, paying little attention to abstract right and justice. Their judicial proceedings were technical to the last degree. Absolute accuracy was required in complying with the established phrases and the acts in the enforcement of civil rights. Any omission or mistake of a word or a movement was fatal. As civilization, however, progressed in Rome, subtle technicalities gave way to simpler methods of pleading. But even then it was found that cases occasionally arose which the improved formulas were inadequate. These extraordinary cases were decided by the praetor without being referred to the ordinary tribunal. And I think that Pilate was a praetor. And without being hampered by any technical requirements as to popular formula of a kind of action, he himself determining both the law and facts in the case. The complainant stated the facts of his case, the defendant set up his defense, the praetor decided. This extraordinary method of determining suits, so simple, so free from technicalities, so easily molded to the exigencies of every case, was found so superior to even the improved formulas that eventually it superseded them and became the only mode of procedure, much as in many of the states and in England the procedure by bill and answer has supplanted the rigid formulas of common law actions. But we have civil actions now. Not only were the pleadings thus simplified by the Roman jurist, but the law was correspondingly improved. A deliberate and persistent effort was made to bring their jurisprudence into perfect harmony with an absolute impartial equity that should do equal and perfect justice to all. And thus was perfected the system of jurisprudence known as the civil law, from which are derived many of the maxims, principles, and doctrines of equity now followed and enforced in the Chancery courts. And we have guys that are called, you got a civil division in your courts. Evolution of equity in England. The development of extraordinary jurisdiction of the Chancery Court of England was similar in its causes, progress, and results to the development of the system of equity in Roman law, as already intimated. In England, the king was regarded as the fountain of justice, and when any person conceived that he had been wronged, either in court or out of court, he had the privilege of petitioning the king for redress. The king, being unable to hear and determine all of these complaints because of their number and complexity, generally referred them to his chief secretary, who was called his chancellor. This officer was an ecclesiastic, a bishop, cardinal, trained in the law and theology at Rome. He was a Catholic bishop, cardinal, and sometimes called the keeper of the king's conscience. When thus directed to adjudicate the rights and determine the remedies of those petitioning the king for justice, the chancellor naturally had recourse to the civil law of Rome, being most familiar therewith, and for also finding therein the diviner sort of justice, and a simpler, more efficient form of procedure. Besides, these chancellors, who were generally very able and very learned men, were no doubt disposed to regard the English common law as barbarous code compared to the Roman civil law. The chancellor's office was one of great trust and confidence. He was the king's advisor, the confidant, the chief member of his council, and the keeper of his great seal of state. He is spoken of at a very early day as one who annuls unjust laws and executes the commands of the pious prince and puts an end to what is injurious to the people or to morals. A good guy to find. Character of the first chancery suits. The chancellors, following the example of the Roman praetors, applied the equitable principles of the civil law to determination of all suits referred to them by the king. The suits thus referred were generally applications to obtain redress for injuries of acts of oppression for which the power of the offender of the offender, or for any other cause, a fair trial in the ordinary courts could not be had. Cases where there were fraud, deceit, dishonesty beyond the reach of the common law, and cases where the common law was inadequate to the requirements of justice. Keep your mind on that thing about out of the reach of common law, because they write the common law in a certain way that certain things can't be undone once they're done. In those times of disorder and oppression, many of the appeals to the king's local magistrates being often overawed, and many were the complaints of want of remedy at law. The king, unable to give personal attention to so many petitions, finally conferred upon the chancellor full authority to give relief in all matters of grace, as these applications for redress returned. And many from this period petitions began to address the chancellor themselves and not to the king. This delegation of authority was made in the year 1348. And in the next 50 years, the equity jurisdiction of the chancellor was clearly established, principles on which early chancellors acted. When matters of grace were thus referred to the chancellor, he issued a writ commanding the party complained against to appear and answer the complaint, that would be a subpoena, and abide by the order of the court. The principles of which the chancellor based his decision were those of honesty, equity, and conscience. By conscience was meant those obligations one person is under to another to exercise that good faith that others have right to expect. On the application to Parliament for redress, the petition was referred to the chancellor with the command, let there be done by authority of the Parliament that which right and reason and good faith and good conscience demand in the case. Okay. On application to Parliament for redress. That's interesting. Matters of grace being thus brought before the chancellor as the keeper of the king's conscience, and he being required to do justice in the king's name, he felt under no obligation to determine the rights of petitions by the law from which they had fled to the king for relief. And for reasons already stated, the chancellors at the early day adopted the equitable principles and simple procedures of the civil law of Rome, adapting them with wisdom and prudence to the emergencies of the particular cases. The matter referred to them being matters of grace and of conscience, the chancellor felt bound to decide the cause according to conscience. The jurisdiction of the chancellor being thus established upon grace and conscience, and his judgment being in the name of the king and by his authority whenever the court of common law were inadequate to determine to the demands of justice, the party unable to obtain relief therein would have recourse to the chancellor, who in his court, called the High Court of Chancery of England, undertook, like the Prarator of England, of Rome, to administer an equity to be not found in the law, himself determining all questions of both law and fact, and rendering a decree adapted to all exigencies of justice. And I think that this is what the Chief Justice plays. That's the part he plays today. Because we don't have kings. So we don't have chancellors. But we do have a king, the King of Kings, and is that his representative here? The common law is compared with the civil law. The common law was then utterly incapable of doing complete justice in many cases, and not a few cases it furnished no remedy or relief whatever. It had certain rigid molds of formulas, in some one of which every cause of action had to be cast. And if the cause could not be run into any of these molds, there was no redress. And if it could not be run into one of the molds, only such redress as the formula could be had. If it could be run into one of the molds, only the redress as the formula gave could be had, regardless of the equities of the case and the real rights of the party. The fictions, formulas, and arbitrary technicalities We're talking about common law now. The fictions, formalists, and arbitrary technicalities of the common law and its dialectic refinements were inexplicable and incomprehensible jargon to the public, and often a costly mockery of justice to the litigant. Jeepers, nothing's fucking changed. Those who asked for bread were often given a stone, and those who applied for fish sometimes received a serpent. Equity, on the other hand, disregarded forms, ignored fictions, subordinated technicalities to the requirements of justice, and indulged in no dialectic refinements. Its pleadings were simple and natural, and its doctrines were founded on the eternal principles of right as interpreted by the lofty Christian morality. And its great underlying principles, the constant source, the never something roots of its particular rules. Dealing roots of its particular rules were the principles of equity, justice, morality, and honesty, enforced according to conscience and in good faith, and so adapted to the requirements on such cases the complications of the business affairs that the rights and duties of all parties were fully determined. And then Henry VIII took over, and it's been downhill ever since. Some of the deficiencies of the common law. The common law, then, was not what it has since become under the benign inspiration of the Chancery jurisprudence. At common law, 1. A vendor's lien could not be enforced. 2. A fraudulent conveyance could not be set aside. 3. A defective instrument could not be reformed. 4. A mistake or accident could not be effectually relieved against. 5. A debt, note, or account could not be assigned. 6. A resulting trust could not be set up. Yada, yada, yada. Let's go back to these first couple, right? A fraudulent conveyance could not be set aside. So even though somebody is taking your property by fraud, if the paperwork is in the right form to be a conveyance, you lose. There's nothing you can do. He who holds the title is the owner. You no longer had the title. Doesn't matter that he took it by fraud. A deed could not be declared a mortgage. A title to land could not be effectually quieted. Waste, trespass, other violations could not be stayed. So, here's a bunch of shit that you can't do in a court of law. Right? All this stuff. So if you couldn't do it in a court of law, I guess you could do it in a court of chancery. And then they refined the common law so that you could do a lot of these things. In fact, in the mid-1800s, there were a couple of acts passed to give the common law courts certain equitable jurisdiction and the Court of Chancery certain common law jurisdiction. I don't know how that all played out, but here's a whole bunch of things that you can't do in common law. The main ones is, if it's a fraudulent conveyance, you can't overturn it. You just have to give your property up. How the law has followed equity. Under the influence of the principles of equity as administered in Chancery, the rugged feature of the common law has grown constantly more and more smooth and humane, and its capacity to do justice has constantly increased. The evolution of law in England and America has been on the lines marked out by equity until the language of Lord Hale, by equity, until in the language of Lord Hale, by the growth of equity on equity, the heart of the common law has been eaten out. To show the effect of the principles of the doctrine of equity upon our own statutes, the following illustrations are cited. The law in reference to gambling and wagering contracts, the whole law of landlords, mechanics, laborers, and other liens, the law on notices through registration of deeds, the prorated distribution of insolvent estates, the appropriation of rents, the provisions of benefit of married women. These are all things that are done in courts of equity. Should be being done in courts of equity. And it goes on and on and on. I don't want to read all those. Okay, so all these statutes were mere enactments of rights recognized and enforced, remedies employed, defenses allowed, procedures used in Chancery Court by virtue of its inherent jurisdiction, and the whole unknown to the common law. Their recognition in our courts of law depending on exclusively upon the statute, and the statute being suggested by the practice in equity. Okay, so all these things that we're looking at now, they used to be done in courts of equity. They tweaked the law to allow them to be done in courts of law by statute, right? Because that's where common law gets its the common law gets its authority from the statutes. And the statute will say to the effect, whoever has the title is the owner. So it doesn't matter if the guy came in your house and stole it. If he's got the title, he's the owner. They didn't think about the fraud part, or they failed to consider that. And so basically what they did is they left it up to right and wrong, and so that's how it worked. The divine law of justice and the rule of decision. The statement often made that the Court of Chancery was established to mitigate the rigors of the common law and to supply its defects is not wholly true. The court was established to do justice regardless of any and all law. That's wonderful. This court was established to do justice regardless of any and all law. We got one court of justice in Michigan. It's the one I want to find, because whatever it is established to do justice regardless of any and all law. The king deemed it a duty imposed upon his conscience, both by his oath and by religion, to decree justice. And in decreeing justice, he deemed himself bound rather by the divine law than by human law, and when the chancellor acted in his stead, he based his decisions not on the law of the land, but upon honesty, equity, and conscience. For so he commanded to do, and exercising the king's prerogative of grace. In short, the Chancery Court was established rather as a court based on the precepts of religion than a court based on the rules of law. It is unquestionably true that the harshness of the common law and its unfitness to cope with fraud, its incapacity to do justice in many cases, with defects in its remedies, the opportunities it gave the strong to oppress the weak, and its general inadequacy to meet the requirements of equity greatly contributed to the perpetuate the existence of Chancery Court and to enlarge and justify its jurisdiction. Nevertheless, vital principles from which the court sprung was the prerogative doctrine of the king was the fountain of justice, and that when a citizen could not get justice in the ordinary courts, he might come to this fountain. The king, in administering justice, in such cases, deemed himself above all the laws and customs of his realm, and bound only by his conscience and his will, as it was not a matter of right in the citizen to draw on the reserved source of justice. When a remedy was given, it was deemed granted as of grace. It's not your right, it's a gift from God. He's going to give you justice. Other causes contributing to the establishment of the Chancery Court, as the Chancery was the office out of which all writs at common law issued. Right? And that's what we're trying to get. We're trying to get a writ of common law called a writ of certiorari. The chancellor retained cases for his own disposition when the facts were such that no common law writ was adapted to the requirements of the case, and when the common law courts were unable to furnish adequate relief. And some contend that herein originated the extraordinary jurisdiction of the chancellor. In this class of cases, the chancellor determined the matters in dispute so the court of the king might not be deficient in doing justice. But it is believed that the equitable jurisdiction of the chancellor originated mainly, if not exclusively, from the reference to him by the king of petitions for justice and redress, as already stated. It is unquestionably true, however, that had it not been for the deficiencies in the common law, the number of these petitions to the king would have been comparatively few. So there's a whole bunch of them because the common law has got nothing but problems in it. It's the court of the Jews set up for them to take your property, and if you don't appeal it to the king's bench to get religion involved, now they're going to let it It's going to happen. When the lay chancellors succeeded the ecclesiastics, King Henry time, no material changes were made in the jurisdiction of the court. Assistants of jurisprudence were, however, enlarged and made more comprehensive. Precedents were more closely followed, and the decisions of the chancellor more carefully preserved. But the equitable principles of the civil law were fully enforced, and the peculiar proofs and practices of the court in all things continued, the lay chancellors being greatly aided herein by the masters in equity, who were permanent officers of the court. Thus was established the High Court of Chancery of England, and thus originated the grand system of jurisprudence known as equity, both maintaining their existence by virtue alone with their inherent merits and their wonderful fitness for the purpose of administrative justice. That's what we're trying to get justice because of administrative actions being taken against us. That's just beautiful. It may be well here to remark that by an act of the British Parliament, which went into operation in 1875, all the great courts of England, including the High Court of Chancery, were consolidated, and a system of pleading and practice adopted similar to those used in Chancery, which is the same thing they did here in America. They combined the Chancery Court and the courts of law into one court. Right? Pleading and practice adopted similar to those in Chancery, but not necessarily the same. The Act of Parliament also provides that in all matters in which there is a conflict or variance between the rules of equity and the rules of common law with reference to the same matter, the rules of equity shall prevail. And thus, in England, the triumph of the righteous principles of equity over the rules of common law is complete and no doubt final. So let it be written, so let it be done. Okay, that was really all I wanted to read on this one. And, okay, so I'm going to hang on a second. Okay, sorry about that. I got chicken noodle soup cooking. I had to get out there and check it out. So anyways, all that so far has been to point out the fact that the king was a fountain of justice. The common law had many, many defects. If you really study it, the defects are put there on purpose so that somebody else can steal your property. And this goes back to 1070 with the Norman Conquest, when the Normans came over and brought the Jews with them. Khazarian Jews, right? There are no Old Testament Jews. None of them can tell you who they're, if you can't follow yourself all the way back to Adam, well, you're not an Old Testament Jew. Even Jesus could. It's in two different versions of the Bible, of the Gospel. So, and they became the king's property. And because they were the king's property, they had the king's protection. And the king took what had used to be the county court that had the earl and the bishop sitting in it. And they took the bishop out and said, well, you go on over here and you do your stuff there, and, we'll take care of things here in town. And they put the Jews in charge, and they made it so that it took the oath of 12 Christians to overturn the oath of one Jew. And they had numerous contracts between the kings of England and the Jews, and one of them was the Magna Carta. So all that common law stuff is there to take your property, man. Just go read it. It's what it says they're doing. And so we need the Court of Chancery / the Court of Equity, or at least its present day manifestation, and that would be whoever can issue the prerogative writs, because those were the writs of the king that he used through the Court of Chancery to administer justice. And then if there's nothing in there that can administer justice, well, then the chancellor just does it on his own. He doesn't really care what the law says. So, but we're going to try to get a common law writ of certiorari. And this is that history of the common law writ of certiorari right here. We're going to read. It's 45 pages long. I don't plan on reading it all, so don't get scared. But it's just good to know where this stuff came from. And so, again, this is just one of the prerogative writs. And the prerogative writs, even though they're used in the court, in the common law court of the King's Bench, they come out of the court of Chancery. They write the writ to be used in the court. So, the writ of certiorari. Many of the present features of the writ of certiorari, which is today in our country the chief means by which the court review administrative actions, review administrative action, can be understood only in the study of its early history. Like most of English writs, it was originally a prerogative writ, i.e., it was issued by the king by virtue of his position as the fountain of justice. Hey, we just read about that. And supreme head of the whole judicial administration. But unlike most of its fellows, which had become what are known as writs ex debito just or writs of right, basically, the certiorari has preserved to a great extent, perhaps to a greater extent than other writs, its original characteristic as a prerogative writ. Writ of right. There you go. If you don't have the right, you don't get the writ. Whereas a prerogative writ doesn't matter. It's not based on right, because the right may say, well, you need to be a citizen of the United States, and we're not, or because we don't have a certificate. Whatever the thing is, they're going to make it, well, you can have them by right, and here's the conditions to have the right, because rights have conditions, where certiorari is just the prerogative of the king by grace. What now is meant more precisely by a prerogative writ? To answer this question requires an acquaintance with the position of the crown in the administration of justice at the time the writ was developed. One of the most important powers which accrued to the Anglo-Saxon chieftains in the transition from a ducal to a royal dignity was judiciary supremacy. The king is the supreme head of a nation, with power over life, limb, and property. The judicial supremacy did not, however, give him the right of pronouncing judgment, for this, in accordance with the Teutonic institution of popular courts, belonged to the members of the community. What it gave him was power to appoint the persons, the sheriffs, who as royal representatives called the popular courts together. Okay, so who is it that calls the courts? Who is it that calls the jury? Because that's the court. Normally it's the popular court is the jury of your peers. They're the court. So who calls the jury? To see that justice was rendered in a case of its denial, personally to judge those powerful litigants who could not be controlled by the popular courts, and to execute or have executed the sentences of the courts. In the Anglo-Saxon system of administering justice, the Norman conquest at first introduced less change than in other branches of government. While in other matters the early Norman kings were absolute in matters pertaining to administration of justice, the system was much the same as it was before the conquest. William the Conqueror bound himself solemnly to maintain good and well-trained laws of Edward the Confessor. This promise meant that the law should be administered by the same persons and for the same persons, by the same persons and for the same persons, and according to the same principles as in Anglo-Saxon days. It is to be noted, however, that the Norman kings reserved to themselves from the beginning the decision on all cases affecting the crown, including the more important criminal offenses which regarded the violations of the king's peace, disturbing the peace, and also cases affecting the revenue. That's what the Norman kings wanted. The judicial proceedings which these cases necessitated were had before the king and the advisers who the transaction of public business had forced him to summon to his side, and who, when united, formed what is known as the Curia Regis or Alua Regis, the court or household of the king. Here the barons acted as judges, the king on their advice giving sentence. Soon this essentially judicial business which was continually increasing, was attended to always by the same persons, and these persons got the name of justices, one of them being called the Chief Justice or Justicar. This Curia Regis soon increased its jurisdiction. The ancient customary process of local courts, with that strict maintenance of formalities and incapacity for regarding equitable considerations, which seems inseparable from the idea of co-purgation or ordeal, was becoming antiquated. As a special favor, suits that belonged before the popular courts were allowed to be brought before the Curia Regis, to be decided by such new methods as the wisdom of the king and his counselors might invent. And from the Curia Regis began soon to issue a series of writs which directed inquiry and recognition of rights as to land, the obligations of tenure, legitimacy of heirs, the enforcement of local justice. These writs were undoubtedly delivered or derived from the process of the Carolingian lawyers. They were the expedients by which the jus honorarium of the king as fountain of justice was enabled to remedy the defects of the jus civil or commune as applied by the local courts. All right, so local courts want to do it one way, and the king said, no, we're going to do it this way. The extension of the jurisdiction of the Curia Regis was accelerated by the partiality of the sheriffs who held the popular courts, and by the fact that these courts race prejudice was found to influence the decision, because the courts were run by the Jews, and it took 12 Christian oaths to overturn one Jew's oath. Soon the officers of the Curia Regis were sent out to the country, at first in the time of Henry I with no great regularity, but later periodically. These officers were known as the itinerant justices, or the justices in ire. They sat in local courts, often taking the place of the sheriff. All right, so that kind of sounds like the appeals court. In the appeals court, showing up in your town, or because they can, the appeals court can hear court any place they want to. In 1178, Henry VIII made great changes to the system. He found that there were too many justices in the Curia Regis to do the work effectively. He therefore chose 5 of his own immediate servants, 2 clerks, 3 laymen, to whom he ordered the complaints of the people to be brought, but reserved the most difficult cases for his own hearing, to be decided as before in the Curia Regis. The delegation of certain of these justices to hear all complaints in due right is regarded, right? That'd be like a general jurisdiction, as the origin of the court of the King's Bench, because the 5 judges chose to sit in banco, Whatever that means. I forgot what that means. All financial suits, i.e. suits relating to royal revenue, were still to be decided by the old Curia Regis, which, when organized for the purpose, was known as the Exchequer. As a result of Magna Carta, which provided for free persons and free property were to be judged according to the law of the land, a special court split from the Exchequer. The Exchequer proper henceforth exercised administrative functions only. The new special court came to be known as the Court of Exchequer. It was organized similarly to the Court of the King's Bench. The adoption of Magna Carta resulted also in the formation of another court, viz., the Court of Common Pleas. The Magna Carta provided that common pleas or civil suits were to be held at some fixed place and were not to follow the king about on his journeys throughout the country. Accordingly, the seat of this court was fixed at Westminster. The itinerant justices of the Curia Regis were soon replaced by justices of Nisi Prius and Assize, who were members of the royal courts. In this way, the entire administration of justice fell into the hands of the judges of the royal courts. But notwithstanding, right, so like the state courts, all the administration of justice within your state would fall into the hands of the royal courts. but not the local courts. But notwithstanding the formalities of these common law courts, the king remained, as before, fountain of justice, for, as we have seen at the time of the formation of the courts, the King's Bench, the king reserved to himself the decision of the most difficult cases. That sounds like what Moses did. This reserved justice resulted later in the formation of another court, which have played the most important part of the development of English law. Further, the development of these royal law courts did not shut the people out of all participation in the administration of justice. The judges appointed by the king were for the most part officers of a professional character. That is, they were educated in law, so the judges were attorneys, but it was only the decision of the question of law that was taken out of the hands of the people and given to the hands of the judges. The decision on the question of fact was still rendered by the people, or by committees of people, which developed into the English jury. By the end of the 13th century, as a result of this development, the judicial supremacy of the king was something quite different from what it had been at the beginning of the Norman period. The king was now the supreme head of the judicial system, the fountain of justice, in a sense until then unknown to Middle Ages. He was in judicial matters what was in other matters practically absolute. All the judges, both at the center and in the localities, were paid servants of the king and subject to his disciplinary power. While actually working on separate lines, the three central courts remained formally connected to the king's personal representative, the chancellor. From his office proceeded all writs which were formulated by the king and his advisers, and by which actions were commenced. Need the writ to commence the action. Writ comes out of the... So you got to get the writ first. The writ comes out of the chancellor's office. By the time the royal courts were fully developed, most of these writs were no longer writs of grace granted by the king in his good pleasure, but instead to litigants upon proper demand, and became known finally as writs by right or something like that, which is what most of them became. Before long, the court to which the application was made issued the necessary writ directed without the intervention of the chancellor. Before long, the court to which the application was made issued the necessary writ without the intervention of the chancellor. It was thus that the court of the King's Bench received the power to issue a series of writs, viz., mandamus, certiorari, prohibition, and quo warranto, through which it controlled the action of the other courts. The King's Bench was regarded as the highest court in the land, with superintendence over all other courts, which court superintends over all the courts in your state, and there was no conscious distinction between justice and administration in the early days over all lower authorities, whatever their nature. This position of superiority over the other authorities was due to the fact the king was supposed to always sit in the King's Bench. But although the writs just mentioned were issued without the intervention of the chancellor, they never became writs since it was only in extraordinary cases that they were issued, and only when some gross injustice was being done by other authorities. So what writs ex debito justitate? And I think that means a writ of right. They never became writs of right. They were always extraordinary writs. It remained the function of the king through his court of King's Bench to judge of the necessity for their issue, and they accordingly came to be known as prerogative writs. And they came to be regarded as among the most important judicial remedies. It must, however, be remembered, when we speak of judicial remedies or of judicial bodies in these early times, that we do not mean what would be meant at the present time by such expressions. Don't think the same words mean the same thing now. As has been shown, the judges of these tribunals had no fixed tenure. Like other royal officers, they were subject to the disciplinary power of the king, and the king was not unfrequently made to use his power to influence their decisions. Right? It happened back then. The king had to do it. It has to be done today. Nothing's changed. Not only was the tenure of the judges the same as the tenure of royal officers in general, but there was no distinction made between judicial and administrative business. The justices of the peace, who had become the most important administrative officers in localities, taking the place originally occupied by the sheriffs, had many important judicial duties to perform and were regarded as judges just as much as members of the royal courts. The Court of King's Bench had powers of control over the justices of the peace, just as it had over all other authorities. It controlled the administration of the government as well as that of justice. Controlled the administration of the government. Controlled the administration of the government. Controlled the administration of the government. Well, it's the government that's administration that's saying that you broke a law. The King's Bench has control over them. The reason why the king permitted the court, the King's Bench, to exercise such control over administrative matters is to be found in the tenure of its judges and in the fact that the king had still powers of reserved justice. He could exercise the strongest personal influence over the judges of the royal courts, and if he found that the administration of the laws were becoming too formal and technical to permit efficient administration, he might exercise his reserved powers and transfer any matter to a newly created jurisdiction. Thus was formed in the time of Henry VII the Court of the Star Chamber, in order to control the nobility who had grown turbulent during the War of the Roses. To this court was given a control over the actions of the justice of the peace, which aimed at correcting not merely their decisions upon questions of law — these were practically the only questions that came up before the King's Bench — but also the questions of fact and of expediency, established originally to protect the weaker classes from the tyranny of the nobility. This court was used by the Stuarts in a fashion that led to its abolition in 1640. The results of the abolition was to remove the justices of the peace from all central control except that which was exercised by the Court of the King's Bench over their decisions on questions of law. To provide some sort of control over the justices acting separately, which should extend to their decisions on questions of fact and expediency, a series of acts of Parliament permitted the individual, when injured by an act of justice in specified cases, to appeal to the Court of Quarter Sessions of the county. This court consisted of all the justices of the court sitting together. And as a result of these statutes, appeals might be taken to the Quarter Session from almost all facts of the justices affecting property rights and personal liberty. There was thus formed in each county, for the decision of administrative questions, a court whose jurisdiction embraced both questions of law and questions of fact or expediency. I wonder who that is. This court consisted of all the justices of the county sitting together. As a result of these statutes, appeals might be taken to the Quarter Session for almost all acts of the justices affecting property rights and personal liberty. See, it's none of the things that we see now. You can't say this is the county commissioners doing this, because they're not elected. They didn't take an oath. They didn't do what was right to be elected in the first place. There's somebody usurping the office of a commissioner, but there is no commissioner there. So this is something that's happening with all the people in the court, just all the justices, right? And that's more like under the bar or something like that. They must have get together 4 times a year, and if we knew where it was, you could go in there and say, hey, I got a question I want you to deal with. Further, the Commission of Justices of the Peace enjoined upon them in difficult cases to take the advice of the royal courts. This came to be done finally by stating a case which was agreed upon by the justice and the parties before them, and which was then submitted to the royal court and finally decided by them. In consequence of these facts, the certiorari lost much of its early importance in England, and its employment. Okay, so this could still be happening in England, the stuff we're reading now. If you're in England, go back and read what I read and see if it applies to you. In consequence of these facts, the certiorari lost much of its early importance in England, and its employment there became less frequent. It had served the purpose of bringing proceedings of the justices and subordinate tribunals generally before the King's Bench for review, which is what we're trying to do. Whatever they call it now, that's what you want to happen. It was often used as a sort of an appellate proceeding against the conviction and orders of the justices of the peace. Right? Because they like to give orders without giving a judgment. But it was more often used for the purpose of removing a case before final judgment, which we never go to, where for some reason it was believed that a fair and impartial trial could not be had. Well, it's because they're not following the law. Indeed, the most common use of the writ in early times seems to have been to remove indictments before the justices. The reason why it was less often employed in appellate proceedings is to be found in the existence of other methods of appeal from final judgments. But we never go to final judgment anymore of the justices, which have been pointed out. Finally, the certiorari was also used in the course of ordinary appellate proceedings to bring up a record of the lower court from whose decision appeal had been taken on the ground the record was sent up was incomplete. Yeah, well, that will happen too, because if you go look in your court case, what you have, and you look at the judge's file, his is a lot thicker. This is called technically certiorari for diminution of the record. The writ of certiorari was therefore used from the beginning for three distinct purposes. First, as a means of removing a cause. Second, to review a determination. And third, as a means of correcting diminution of another proceeding as an auxiliary remedy. It is to a consideration of a certiorari as an independent appellate proceeding that this article will be devoted. In our country, this is by far, now this is America, in our country, this is by far its most important use because, for a number of reasons, we have been unable to develop generally any such method of appeal from administrative decisions as have been created in England. Any such method as to appeal to the quarter sessions or to the statement of the cause. These are things for England. Find them words being used today, you're getting in the right area. There are indeed throughout our southern commonwealths instances of appeals from decisions of administrative officers to the county courts, which have largely taken the place of this country, the English courts of quarter session. Okay, so the county courts took the place of the quarter session. And there are very few instances of such appeals in other commonwealths. But in general, our only method of appeal for administrative decisions has been by certiorari, and we have therefore been obliged to give to this writ a development which was greatly enlarged in scope and usefulness. Before I attempt to trace this development, it will be well to indicate how far the certiorari has retained its original prerogative characteristics and what court may issue the writ in the United States. And for more, you're going to have to read the rest yourself. And you can find this again. It's called The Writ of Certiorari by Frank J. Goodnow. Google it. I'm sure you'll find it. You can download it. You can download it from this site here. Stable URL, www.jstor.org. Stable 213-9490. All right. I hope if you didn't find it really useful, what can I say? I just like to read sometimes, so that if anybody questions later why I say what I say, I can say, well, I put it in the video. And here you go. This is why courts of common law, not so good. right? We need to. They have defects built in, and we need to get to the Court of Chancery or whatever they're going to call it today and use prerogative writs in a system that's been around for 1,000 years, and really nothing's changed. Just the names have changed, and we've been dumbed down. So let's get smarter. Okay, y'all have a great day.